Theft of information via computer networks is on the rise. Most of these crimes take the form of theft of personally identifying information or financial information. Financial gain is nearly always the motive for these crimes. The US Federal Trade Commission (FTC) states that fraud and identity theft were number 1 and 2 respectively on its list of top 3 consumer complaints. The Federal Identity Theft Assumption Deterrence Act of 1998 makes identity theft a federal crime. The law makes it illegal for anyone to knowingly transfer or use another person's identification with the intent to commit a crime. Identifying information includes items you may be familiar with as personally identifiable information, such as name, social security number, and driver's license number. It also includes unique biometric data, such as fingerprint, voice print, retina, or iris image, or other unique physical representation. Address or routing code, electronic serial numbers that identify a specific communications device or account, or any other piece of information that may be used to identify a specific person. If a person violates the law, he is subject to fines and criminal penalties up to 15 years in prison. This period increases to 30 years in special circumstances, such as where identity theft is used to facilitate terrorism. Violators also must give any personal property used to commit identity theft crimes to the government. The Secret Service, FBI, US Postal Inspection Service, and the Social Security Administration offices all have the power to investigate crimes committed under this law. Cyber squatting sounds an awful lot like cyber stalking, but is a completely different cyber crime. It is the bad faith registration of a domain name that is a registered trademark or trade of another entity. In the US, the domain whitehouse.com is one of the earliest and most well-known cases of cyber squatting. In 2001, the movie star Nicole Kidman took legal action against a website called NicoleKidman.com, a typo-squatting domain that took advantage of the alternate spellings of the actress's first name. The domain was registered by an individual who tried to pass the website off as the real Nicole Kidman. The computer giant Dell took successful legal action against 3 website registrar firms in 2007, accusing them of unlawfully registering and profiting from 1,000 domain names that were confusingly similar to Dell's own trademarks. Congress created the Anti-Cybersquatting Consumer Protection Act, or the ACPA, in 1999. It is designed to stop people from registering domain names that are trademarks that belong to other entities. The ACPA allows entities to sue cyber squatters. To prove such a case, the plaintiff shows that the cyber squatter registered the trademark in bad faith with the intent to profit from the registration. The ACPA includes 9 factors that help a court determine bad faith, such as the person's intent to divert consumers from the mark owner's own website, offering to sell the domain name without having used it for the sale of goods and services, and giving false or misleading contact information when registering the domain name. Under the law, a plaintiff can recover damages and ask the court to issue an injunction that stops the cyber squatter from using the contested domain name. Courts also can award the contested domain name to the winning party. Torts are wrongful acts between individuals. Lawyers and commentators have started to use the term cyber torts to describe torts arising from internet communications. Terms are trendier when cyber is added as a preface. Courts are applying traditional tort law principles to areas where communication and personal interactions occur electronically. Defamation is an intentional tort. Defamation occurs when one person speaks or publishes a false statement of fact about another person that injures that person's reputation. There are 2 types of defamation cases. Libel is written defamation, and slander is oral defamation. The distinction between libel and slander has diminished in recent years, with defamation being used generally to refer to both types of cases. Defamation cases in cyberspace involving written communications are considered libel cases. To prove defamation, a plaintiff must show that the defendant made a false statement of fact. A defamatory statement must be more than mere opinion. Now, I'm sure that everyone has left a review on Amazon for something they purchased, or at least research reviews before purchasing something online, right? Now, for instance, in Hammer versus Amazon.com in 2005, the plaintiff, a self-published author, sued Amazon.com for defamation. An online reviewer gave the plaintiff's book a negative review, which Amazon published. The plaintiff wanted Amazon to remove the review, which it refused to do. The court ruled that the reviewer's statements were opinion and could not support a defamation claim. The defamatory statement must be published to third parties. The publication requirement is easily satisfied when information is posted on the internet. In fact, because many people have access to the internet and materials posted on it, it may be easier for a plaintiff to show publication in an internet defamation case. Information posted on the internet may reach an audience more quickly. It also could lead to greater damage to the plaintiff. Finally, the plaintiff must show that the defendant knew or should have known that the statement was false. A plaintiff shows this by presenting evidence that the defendant did not check facts or the source of a statement.